Hi everyone, this is Anukriti from Easinglaw. So here's a small presentation by me on FEMA Non-Debt Instrument Rules 2019. These rules have superseded transfer of issue of security by person resident outside India and acquisition and transfer of immovable property in India regulations 2018. So basically ये जो दोनों regulations है, they have been superseded by FEMA Non-Debt Instrument Rules 2019. So these rules states that the rules are regulated by Finance Ministry and the manner of receiving payment and reporting is regulated by RBI. तो इसका मतलब क्या है कि जिस मोड में पैसा आने वाला है, the mode in which the payment has to be made is regulated by Reserve Bank of India. So basically, what is non-debt instrument? Non-debt instruments means which do not create any debt. So that can be an equity instrument, that can be an investment in mutual funds or an investment in capital investment in LLP or an acquisition of immovable property. Going ahead, Rule 3, 4 and 6 have been presented on the slide here. Rule 3 states that no person resident outside India shall make an investment. However, if the RBI grants the application and the reason may permit the investment. इसका मतलब ये हो कि पर्सन रेसिडेंट आउटसाइड इंडिया ऐसे तो कोई भी इन्वेस्टमेंट नहीं कर सकता इंडिया में, बट इफ द आरबीआई परमिट्स द सेम कैन बी डन. Rule 4 further restricts on receiving investment. So it states that other than rules and regulation, no investment in India is to be received from person resident outside India. But if the RBI permits and grants the application, the investment can be received in India. The investment by person resident outside India have further been restricted to citizens or entities of Pakistan and Bangladesh. And then the additional restriction has been put on citizen or entities incorporated in Pakistan. It states that there is additional restriction on the citizens and, or entities in that these अगर हम इसका लॉजिक देखेंगे तो बेसिक लॉजिक इज जस्ट इन द interest of the country or for the purpose of security. Going ahead, if we see Rule 5 provides that the investment into India shall be subject to these three points, that is entry route, sectoral cap and investment limit. Investment limit is provided. Entry route मतलब किस तरीके से the investment shall be made. How shall the investment enter into India? It can be either automatic or through government approval route. The automatic route is where the investment does not require prior approval of any government, whereas the opposite of it is the approval route, where the investment of the government is prior required before making any investment. Sectoral cap दो तरीके से governed है, that is it can be foreign investment, and if it is a foreign investment it can be under repatriation basis for equity capital and capital of LLP only. So repatriation basis, I hope to everyone it is clear that what is repatriation basis. Please answer me in the comment box here. So repatriation basis, अगर आपको repatriation basis में investment करना है तो आप equity capital and capital of LLP पे ही कर सकते हैं. Then if the sector specified in table, अगर आप जो sectoral limit है, if the rules provide the same in table, it shall be up to the limit that is provided. Up to the limit means that is the maximum investment in which the foreign investment can be made. And if no limit has been provided under that table, it is under automatic route and 100% of it can be invested. Moving ahead, certain sectors have been prohibited for FDI. The sectors list are provided here, which you can see on your screen. That is gambling, needy company, lottery business, etc., which you can see. But अगर हम रियल एस्टेट बिजनेस और कंस्ट्रक्शन ऑफ फार्म हाउस की बात करते हैं तो रियल एस्टेट बिजनेस और कंस्ट्रक्शन फार्म हाउस हैव बीन रिस्ट्रिक्टेड, बट द फोर मेंशन्ड पॉइंट्स, द हाइलाइटेड पॉइंट्स आर नॉट कवर्ड अंडर द रियल एस्टेट बिजनेस और कंस्ट्रक्शन ऑफ फार्म हाउस. सो बेसिकली दीज 4 points, that is developing of township, realty is broking, investment in REIT, and the construction of residential or commercial premises are those sectors where the investment can be made easily. These are not restricted for the purpose of FDI. Then let's come to Rule 7. Rule 7 says that if the acquisition through right issue or bonus issue is to be made in securities, how the same is to be done. Rule 7 first of all provides what things are to be complied. The very basic of it is compliance to the rules and regulation, that is compliance of the Companies Act. The second is it should not breach the sectoral cap. As we have discussed, the sectoral table is completely provided under these rules. So that limit should not be breached while you are acquiring any securities issued through right issue or bonus issue. The third one we will be discussing. Let's come to the fourth point, that is person resident outside India can exercise this option, but only on non-repatriation basis. That is, the issues can be subscribed only on non-repatriation basis. The price is to be determined in case of listed company by the company itself, and in case of unlisted company, it is to be determined by person resident in India. The investment by FPI. So this again the limit has been imposed on foreign portfolio investors. That is, each FPI should hold the total holding should be less than 10% of the total equity capital. That is, individual FPI cannot hold more than 10% of the total equity capital of that company, and the aggregate holding of all the FPI together shall be as per the sectoral cap which has been provided under these rules. तो अगर हम देखेंगे तो ये दो लिमिट्स प्रोवाइडेड है एफपीआई के इन्वेस्टमेंट के लिए. पहला तो ये है कि द लिमिट शुड नॉट एक्सीड द सेक्टोरल कैप, है ना. जब एग्रीगेट एफपीआई आ गया, अगर 100 एफपीआई तो 100 एफपीआई का मिला के भी जो सेक्टोरल लिमिट है दैट शुड नॉट एक्सीड, एंड दैट 100 ईच एफपीआई शुड नॉट होल्ड more than 10% of the total equity capital of the country. अब एफपीआई जो है वो किसी भी इक्विटी इंस्ट्रूमेंट में इन्वेस्ट कर सकते हैं, डोमेस्टिक म्यूचुअल फंड में कर सकते हैं, एआईएफ में कर सकते हैं, रियल एस्टेट इन्वेस्टमेंट ट्रस्ट में कर सकते हैं. गोइंग अहेड अगर हम देखें ट्रांसफर ऑफ इक्विटी इंस्ट्रूमेंट बाय एफपीआई, वो क्या बोलना चाहता है. द रूल 11 states that such transfer shall be as per the prescribed schedule and specified by SEBI. Agar if an individual who is an FPI is willing to transfer the equity instruments which he has bought, can be made only after he abides by the rules and regulations which have been specified by SEBI. The transfer by way of sale or gift of equity instruments to any person resident outside India shall be done only under approval rule. That means if the equity instrument is to be transferred or sold to person resident outside India, it should be done only after the approval from the government has been received. The third point is important, which states that if the equity instruments while they are being transferred breaches the sectoral limit, अगर sectoral limit breach हो जाती है, जैसे मान लो कोई FPI के पास में already 8% के equity capital है, that is equity shares है उस company के, and then he receives gift of additional 3%, that means he is exceeding 10% cap. The same has to be divested within 5 working days, and if not, the same shall be treated as FDI. The total 11% received shall be treated as FDI. Now let's come to investment by NRI or overseas citizen of India. The difference between NRI and overseas citizen, I hope it is clear to everyone, and I'm awaiting your comments here. So it states that investment by NRI or OCI can be made under repatriation basis or on non-repatriation basis or Indian depository receipts. The repatriation basis, the rules and the details are provided under Schedule 3 of these rules. The non-repatriation basis is provided under Schedule 4, and the Indian depository receipt is provided under Schedule 10. Let's come to repatriation basis. अगर repatriation basis पे investment होनी है, then these are to be made under the 4 mentioned sectors which you can see. That is, it can be made under equity instrument, or in mutual fund, the public sector, or under NPS, that is National Pension Scheme. Equity instruments में the individual's investment should not exceed 5%, and the aggregate of all the NRI or OCI should not exceed 10%. The limit of 10% can further be increased to 24% if the special resolution is passed in general meeting. Under mutual fund, there is no limit. The investment can be made completely, but then that fund should invest more than 50% under इक्विटी इंस्ट्रूमेंट्स ओनली। तो म्यूचुअल फंड में आप कितना भी इन्वेस्ट कर सकते हो, दैट इज इफ अ पर्सन इज एन एनआरआई और ओसीआई, इन्वेस्टमेंट कितना भी हो सकता है, बट वो उसी फंड में होगा वेयर 50% ऑफ द इंस्ट्रूमेंट्स आर इन्वेस्टेड अंडर इक्विटी। The public sector के लिए there are certain terms and conditions. If the NRI or OCI abides by it, the investment can be made for repatriation basis. Now let's come to non-repatriation basis. For non-repatriation basis, the Schedule 4 further provides the detail. If you will see, there is a list on which investment can be made by NRI or OCI. The list states that the listed securities can be invested on non-repatriation basis. The capital in LLP, the sole proprietorship, and the partnership firm's capital. But kuch jagah investment cannot be made. It is in somewhat similar to where the FDI cannot be made. If you will see this list, it is similar to the one. Going ahead, let's see Rule 13, that is transfer of equity instrument by NRI or OCI. अगर हमें equity instruments को transfer करना है, तो अगर if that is the holding which is on non-repatriation basis, how shall the same be done? It can be either the sale to any PROI or it can be a sale to any NRI or OCI. पर्सन रेसिडेंट इंडिया को होगा तो फिर तो कोई रूल्स एंड रेगुलेशन लगते ही नहीं है. सिंस दिस इज टॉपिक ऑफ फेमा, तो दो ही जगह इन्वेस्टमेंट ट्रांसफर हो सकती है, या तो पर्सन रेसिडेंट आउटसाइड इंडिया को होगी या तो एनआरआई और ओसीआई को ही हो जाएगी. If an investment is being transferred from NRI or OCI to person resident outside India, 4 things have to be considered. That is entry route, the sectoral cap, the pricing guidance, and the other condition. And if the same is being transferred from one NRI or OCI to another NRI or OCI, nothing is to be complied. Going ahead under this rule only, if we see that if the holding of equity instrument is under non-repatriable basis, if the gift is to be made to person resident outside India, the prior approval of the government along with the forementioned things have to be abided. Only then the gift to person resident outside India shall be a valid gift. और अगर हम नॉन रिपाट्रिएबल बेसिस वाले इक्विटी इंस्ट्रूमेंट्स हैव बीन गिफ्टेड टू एनआरआई और ओसीआई, there is only one condition. So let's discuss this. वो क्या बोलना चाहता है कि अगर कोई नॉन रिपाट्रिएबल बेसिस इक्विटी इंस्ट्रूमेंट अगर है, तो अगर एनआरआई और ओसीआई उसे पर्सन रेसिडेंट आउटसाइड इंडिया को गिफ्ट करते हैं, the forementioned things, that is the sectoral cap should not be breached, it should not exceed $50,000. वो जो 9 है, that is my typing error. It should not exceed $50,000. The second point states that the gift does not exceed 5% of the paid up capital. That means the gift should not exceed the 5% of the paid up capital of that company. And lastly, the donee should be eligible, and both the donor and donee should be a relative falling under the definition of relative as per the Companies Act 2013. So अगर ये 4 condition है, along with if the government grants approval, the gift can be made to person resident outside India. If the gift is being made to NRI or overseas citizen of India, then only one thing is to be considered, that is the non-repatriable basis पर ही holding होनी चाहिए. Because अगर non-repatriable basis पे पहले किसी NRI ने hold करके रखा था, and if the same is being transferred, or I should say gifted to another NRI or OCI, the same should be held on non-repatriable basis only. Then let's come to Rule 24, that states acquisition and transfer of immovable property in India by NRI or OCI. The NRI or OCI, how will they acquire immovable property? They can acquire immovable property through following modes. That is, if you will see, inward remittance from place outside India. अगर आपके पास में कोई remittance आया, if you're holding funds under NRI account, if you have received any gift from person resident in India or NRI or OCI, or if you have received any inheritance from person resident in India, you can transfer, you can acquire the immovable property through same. But no property shall be bought if it is an agricultural land or a plantation property or farmhouse. ये 3 sectors में कभी भी investment नहीं हो सकती by NRI or OCI. So I have mentioned this as APF as a short form through which you can revise. अगर ट्रांसफर करना है अगर किसी एनआरआई और ओसीआई को, if they are willing to receive, these 3 properties shall only be transferred to person resident in India, और किसी एनआरआई और ओसीआई, no NRI and OCI can hold this property. Now let's come to a question where spouse of NRI or OCI can jointly acquire a property. If the spouse of NRI or OCI is willing to acquire property jointly, so how is to be done? So let's understand what is the definition of spouse here according to the rules. It states that the marriage should be registered and the marriage should have subsisted for more than 2 years. मतलब शादी को 2 साल हो जाने चाहिए, and it should be a registered marriage. Then let's come to first point, which states that the person resident outside India is the spouse of NRI or OCI can acquire immovable property other than APF. इसका मतलब ये है कि जो spouse है, he or she should not be NRI or OCI, but should be a person resident outside India. तो किसी भी NRI या OCI का जो spouse है, that person should be resident outside India and can acquire property, immovable property, except APF, that is agricultural land, plantation property, and farmhouse. The consideration is that consideration is to be paid for acquiring the property only through funds received in India through inward remittance or the funds held in NRI account. Furthermore, no consideration shall be paid from traveler's check or foreign currency coins. Now let's come to Rule 26 and Rule 27. Rule 26 states that a person resident outside India can establish a branch office in India and can acquire or mortgage property. मतलब जो person resident outside India वो for the purpose of his business can establish any branch office, can acquire any can acquire or mortgage property. But the persons of these mentioned countries, which you can see on your screen, that is Pakistan, Bangladesh, Sri Lanka, Afghanistan, China, Iran, Macau, Nepal, ये जो कंट्री के सिटीजन्स है, they can acquire immovable property if they get a prior approval from RBI. And the second condition, if they need property on lease, the period of lease should not exceed 5 years in order to get the same without the prior approval. इसका मतलब ये कि अगर 5 साल से ज्यादा की लीज चाहिए ना तो परमिशन लेनी पड़ेगी. अगर if it is less than 5 years तो लीज के लिए परमिशन लेने की जरूरत नहीं है. But if you are acquiring the immovable property, then RBI की परमिशन जरूरी है for the citizens mentioned here in the स्लाइड. जो भी कंट्रीज का नाम है, इन कंट्रीज के सिटीजन्स को, अगेन आई एम रिपीटिंग, कि इमूवेबल प्रॉपर्टी अगर एक्वायर करना है तो प्रायर अप्रूवल ऑफ आरबीआई की जरूरत पड़ेगी. इफ द सेम इज टू बी मेड थ्रू लीज, तो उस केस में द पीरियड शुड नॉट एक्सीड 5 years if no permission is to be required. Then now let's come to Rule 27. Rule 27 क्या बोलता है कि foreign embassies, diplomats, consulate general can purchase or sell any movable property, but only after receiving clearance from Ministry of External Affairs. अगर आपको कोई बेचना है या खरीदना है, if you are a diplomat, if you are a foreign embassies, consulate general, then you have to seek permission from Ministry of External Affairs, and the same is to be made only through normal banking channel. The reason why the normal banking channel is clearly specified is if in future something an investigation is to be made, it becomes easier to trace the sequence of the money, to trace the channel of the money, the trail of the money. So in order to make it clear, it has clearly been mentioned that normal banking channel के through payment होगा. Future में कोई discrepancy आएगी, so that would make the investigation little easier. Now let's come to investment by फॉरेन वेंचर कैपिटल इन्वेस्टर. अगर हम बोलेंगे कि फॉरेन वेंचर कैपिटल इन्वेस्टर क्या है, फॉरेन वेंचर कैपिटल इन्वेस्टर इज बेसिकली अ पर्सन हु इन्वेस्ट इन वेंचर कैपिटल. ही इज अ फॉरेन पर्सन हु इन्वेस्ट इन वेंचर कैपिटल. तो फर्स्ट पॉइंट ये है कि इन्वेस्टमेंट शुड बी मेड इन लिस्टेड और अनलिस्टेड सिक्योरिटीज, यूनिट्स बाय वेंचर कैपिटल फंड, एंड इट शुड बी मेड अंडर स्टार्टअप इंस्ट्रूमेंट्स. It can be a purchase from issue of security or person holding instrument. So इसका मतलब ये है कि जो फॉरेन वेंचर कैपिटल है, या तो वो फ्रेश इशू ऑफ सिक्योरिटीज में इन्वेस्ट करे, नहीं तो जो एग्जिस्टिंग पर्सन है उससे वो इंस्ट्रूमेंट्स, द वन हु इज होल्डिंग, उससे वो बाय कर ले. पहला चीज है. दूसरी चीज ये बोलता है कि जो मोड ऑफ पेमेंट होगा दैट शैल बी डिसाइडेड बाय आरबीआई, है ना, एंड द प्राइस इज टू बी डिटरमाइंड बाय द पार्टीज mutually agreeing to each other. That is, the buyer and seller should mutually agree to each other on the price. The mode in which the payment is to be made is to be decided by RBI. It can be in form of issue of security or person holding instrument. And last but not least is the investment should be in listed or unlisted securities. It can be in the units of venture capital funds and the startup instruments. Then let's come to issue of convertible notes by an Indian startup. ये बोलना चाहता है कि जो कन्वर्टेबल नोट्स जो इशू होते हैं ना, दैट कैन बी मेड टू पर्सन रेसिडेंट आउटसाइड इंडिया एंड टू एनआरआई और ओसीआई. अगर एनआरआई और ओसीआई को इशू करना है, देन इट शुड बी ऑन नॉन रिपाट्रिएबल बेसिस ओनली. बट अगर पर्सन रेसिडेंट आउटसाइड इंडिया, तो उसके लिए 3-4 कंडीशन, लेट्स गो थ्रू इट. द फर्स्ट कंडीशन व्हिच आई ब्रीफली मेंशन्ड इज पर्सन रेसिडेंट आउटसाइड इंडिया कन्वर्टेबल नोट्स के लिए कोई भी हो सकता है एक्सेप्ट द सिटीजन्स ऑफ पाकिस्तान एंड बांग्लादेश. सेकेंड इज गवर्नमेंट अप्रूवल सेक्टर में अगर आप कन्वर्टेबल नोट्स बाय करना चाहते हो, देन इट शुड बी ओनली आफ्टर रिसीविंग अप्रूवल फ्रॉम गवर्नमेंट, एंड द अमाउंट शुड बी ऑफ एटलीस्ट 25 lakh in single tranche. That means the 25 lakh is the minimum amount for buying the convertible notes issued by an Indian startup. So here is the end of video. This was a small initiative which was taken by me in order to explain foreign non-debt instruments. So guys, basically this is my second video. I hope you liked it. You can post your queries and I'm awaiting your answers, defining what is repatriation basis, the difference between NRI or OCI. If you have any other query, you can join my Telegram channel. Provided under the description. You can visit if you want to know about who I am, what is my background. You can visit my LinkedIn profile. You can also visit my Instagram page called Easinglaw. You can post your queries here. You can DM me there, and definitely I'll answer you and make a law little easy for you. Thank you.